May I please, Your Lordship? Yes. Your Lordship, I beg to mention item number 9. Your Lordship, in this contempt petition, I have been instructed to appear for contender number 1 and 2.
Yes.
And I've received the necessary instructions also. So kindly grant me 2 weeks to file my affidavit.
Third Learned Counsel, Ms. A. Ayani, who submits that she has received instructions to appear on behalf of respondents number 1 and 2 and prays for 2 weeks' time to file the counter affidavit on behalf of respondents number 1 and 2. So, Learned Counsel for the petitioner, Ms. Such and Such is present. List after 2 weeks.
Much obliged, Your Lordship.
May I please, Your Lordship?
Yes.
Your Lordship, I beg to mention item number 5 on behalf of Nisika Chishi for respondent number 2. Your Lordship, kindly this matter may be listed after 3 weeks since the respondent is yet to file affidavit in opposition.
It's a criminal petition.
Yes, Your
He
Lordship.
wants to file objection.
Yes, Your Lordship. Also, I've been told that the parties are trying to settle amicably.
Okay,
So,
okay, outside the court.
Yes, so kindly grant us some time.
Learned Counsel, Ms. Such and Such submits on behalf of Mr. Misuka Chishi for the respondent number 2,
Respondent
number 2, and prays for 3 weeks' time to file an objection on behalf of respondent number 2. Learned Counsel for the petitioner, Mr. Medovero is present. Stop Learned PP, Ms. S. Mary is present. Stop list after 3 weeks. The interim order passed earlier shall continue till the next date.
May I please, Lordship?
Yes.
Lordship, I beg to mention item number 17 from the hearing list. Lordship may kindly grant 3 weeks' time to file rejoinder affidavit filed by the petitioner, Lordship.
You want to file a rejoinder?
Lordship.
Lordship, I'm for the petitioner.
Petitioner? Yes.
For the petitioner.
Sir, City
We would
Romsong?
also like to reply.
No, it's up to
we
you.
will-
It's up to you. Yes.
Yes, we will also like to file a reply to the rejoinder affidavit filed by the private respondent. Lordship.
Okay, okay. So 3 weeks' time.
Lordship.
You also want 3 weeks' time. Heard Learned Counsel for the petitioner, Mr. C.D. Rongsong, who prays for 3 weeks' time to file a rejoinder to the counter affidavit filed by the respondent number 5. Learned Government Advocate has also prayed for time to file a reply.
Lordship.
File a
Rejoinder.
rejoinder to the reply filed by the petitioner. So accordingly, prayer is allowed. List after 3 weeks.
I would like.
Obliged, Lordship.
Yeah, we'll have to mention item 15. Hearing list. Yes, this matter may come up after 3 weeks. Yes, with the consent of the opposite counsel.
Where is the
Mr.
other
Thiba.
side? You have obtained the
Yes, I
consent.
have obtained the consent.
Learned Counsel for the petitioner, Mr. L. Iralo, who prays for 3 weeks' time with the consent of the other side. So prayer is allowed. List after 3 weeks.
There's an interim that may be
The
continued.
interim order passed earlier shall continue till the next
Number
date.
next.
May I please, Your Lordship? I beg to mention here in item number 13, Your Lordship. Since
Number
13,
13.
yes, Your Lordship. Since my seniors had disposed, and we have taken consent from the other party, Your Lordship. If the matter can come up after 2 weeks, Your Lordship.
2 weeks.
Yes.
Learned Counsel for the petitioner, Ms. Such and Such, makes a mention on behalf of the leading counsel, Mr. N. Longkamar, who's indisposed, and prays for 2 weeks' time. The learned government advocate has no objections. List after 2 weeks. Yes.
I would like.
Yes, Your Lordship. Lordship, I beg to mention hearing item number 14 on behalf of Senior Counsel Justice for the Counsel for the petition.
Petitioner.
Lordship, since the Senior Counsel is indisposed, if the matter may come up after 4 weeks.
Who's the senior? Kedovi.
Justice
Zazit Soleh. Okay. Learned Counsel for the petitioner, MS Such and Such, who makes a mention on behalf of the leading counsel, Mr. Zazit Soleh, who is indisposed, and prays for 4 weeks' time. Learned Government Advocate has no objection. List after 4 weeks. Yes.
Please, Lordship, please allow me to mention hearing item number 16. On behalf of respondent number 1, I pray for 3 weeks' time to file my affidavit in opposition.
You are yet to file your counter affidavit. Okay. Learned Counsel for the petitioner is present. Learned Counsel, Mr. Pakrin Chapo appearing for the respondent number 1 has prayed for 3 weeks' time to file his affidavit in opposition. Prayer is allowed. List the matter after 3 weeks. It's already in the hearing list. How come you are yet to file your counter?
This matter.
Yes.
My lord, we have recently implemented new party.
Oh, okay. New. Okay. After 3 weeks, no? Yes.
Obliged.
For motion, item numbers 1, 2, 3. Before my learned friend begins, Lordship, apparently there are some new IAs that has been filed. I have not been served with any copies.
Acha. Yes, IA 36.
Apparently 135 in
136, 137.
These are new IAs.
And 138. I think. 136, 137, 138. You have filed it?
Yes.
This is
yes,
for?
Your Lordship. It's for impleadment of the 3 minor children of respondent number 1, Your Lordship.
Which one? Which one is which? There are 3 IAs.
There are
that
3
have been
IAs.
Yes.
So 136, 137 and 138. Have you served copies?
I have just received the office.
Okay.
Lordship, but on the objection that I have raised, Lordship, my humble submission, may I just submit? I'll take a short time, Lordship. Lordship, the IA, the present IAs, as stated by my learned friend, pertains to the impleadment of the minor children who were party to the from the in the tribunal.
In the tribunal.
In the tribunal. Lordship, that objection, non-joinder of necessary parties, was addressed by me in my objection, and it has the appellant has come forward for impleadment of the minors only after my objection has been filed. Lordship, whether that.
See, this court would like to go on the merit, and
Yes,
I think it's
okay.
better always to go on the merit instead of going for all these technicalities.
Lordship, second, my
because they were already there before the trial court.
Yes.
It's just that due to inadvertence, maybe they have not included it.
Lordship, and the second
Yes.
objection that has been raised in my written objection, they have come before this on suppression of material facts. Lordship,
What
because
facts again?
Lordship will kindly say that in the month of June 2024, execution case was filed on the degree. We have served notice on the appellant 4 times, and in terms of the order of the learned tribunal, on 12/12/2024, we were asked to publish it in the newspaper, daily newspaper, and that has been done on the 17th December issue of the Morong Express.
Regarding the execution.
Yes, the pendency of the execution case. But without attending to the execution case that has been pending before the trial court, they have come with this appeal. And that also
You have
after
not entered appearance in the execution
Lordship,
case.
one counsel appeared in August 2024. They appeared. It's clearly there in the in my objection letter. I have enclosed those, the orders. Page 9, Annex 1 to my objection, Lordship, is the execution petition. Lordship has got it. Batch 9 of
In
my
your
objection.
objection
Yes. Against the condonation.
in MSC 5.
Yes. IA 5. IA 54, Lordship.
In IA 54. Annexure 5.
Annexure 1, Lordship.
Annexure 1.
It begins with
Yes.
batch 9.
Execution case 1 of 24.
Yes, Lordship will see that respondent number 3. This is the present appellant. And then, Lordship, the next is 16. Page 16.
Granted search and search for the
Yes.
decree holder. And
This is an order passed by the learned tribunal, Lordship, in the execution case 1 of 2024.
Okay, one Mr. Edison Mathai.
Then the next is also another order, Lordship, page 17. Lordship, on the first order 16/8/2024, page 16,
On 16/8/24,
Mr.
one Mr.
Edison-
Edison had appeared
Yes.
for the judgment letters. Then after that, no one appeared.
Yes. Then, Lordship,
Then on
by the order dated
12/12,
12/12/2024,
12/12.
at the bottom of,
Yes.
I was,
So none of these are mentioned in the
yes,
appeal.
not a whisper, Lordship, both in the appeal as well as in the condemnation application.
Anyway, on what ground are they coming? The appeal, on what ground have they filed?
Lordship, they have taken 4 grounds, which I consider to be important grounds. Lordship, but one is that,
I think we'll have to consider on merits actually.
Lordship,
Yes. We'll see. The suppression also that can be considered at the time of hearing. Since you have already taken.
yes, Lordship.
Yes.
My prayer is that, Lordship,
For now,
the
this will
impleadment
be
of
allowed.
the
This can be
minors
allowed.
will not help the appellant. I'm not against
No,
the
just
impleadment. I'm not-
procedurally, since they have to implead, let it be impleted.
And Lordship,
And then it can be heard finally.
I have a citation and that also, Lordship, otherwise. That at the balloted stage, no impleadment petition can be made by the Supreme Court.
No, depends on whether they were already appearing before the trial court or not.
Lordship, you were the
No,
claimant.
in that cited case. A new.
From the very
a
beginning,
new-
they failed to implead in this case.
See, that's why I'm saying.
They failed to implead.
Even before the tribunal, they did not implead. In that case, this court cannot allow. But since they were already appearing in the trial court, so this court will have to allow this one. That is, the facts are slightly different. Because at this appellate stage, obviously, if
Yes.
they were not impleted before the trial court, the court cannot
No,
allow.
the Supreme Court says that once objection has been raised, they cannot. That's the suggestion.
It's okay, this will not spoil the case, or this will not, improve or
Lordship,
do anything to the
I-
case.
right.
It is just
That-
that the procedural lapses are there, so they have to comply, that's all. In all three,
Yes, Your Lordship.
there are three appeals here.
No,
That
there's
means-
MSC Appeal 5 of 2025, 54 and 55 of IA. One is delay, one stay, Your Lordship.
No, today's
Today's
motion.
3 IAs.
Today's three IAs, all three are for impleadment.
Yes. One is
So
for
far
the-
as impleadment concerned, I have no objection, Lordship, if Your Lordship has, since Your Lordship has taken that
Yes.
stand. But anything other than impleadment,
No, only the
only,
impleadment.
we have only for
valuable right of the degree holder has been snatched away because of the negligence.
And why you have not stated anything about the execution proceedings also, that's another point will be considered during hearing.
Your Lordship is not considering the condonation petition at this stage.
No. Continuation for how many days?
No, so many days.
Okay.
At one stage, there are 280 days, and the appellant has been sleeping all along.
Okay. Which one is the impleadment? 136?
136, yes.
136. 136, okay. IA 136.
I don't know why three.
No, that's why.
Yes. That's why. Let me. Since I've just received it,
Because
Lordship, I've not gone through.
MEC is only MEC 5.
Yes.
Yes,
MSc
appeal
5
is
of
only
25.
One appeal.
Then why 3 IAs for
But
impleadment?
in the IA 54 and in IA 55 for the stay in delay, we have also not impleaded the necessary parties, so we have filed different IA for both the IA also.
Okay, which one is for
okay,
which one?
okay. Which one is in the main petition? IA 136.
Yes, the Lordship.
Okay, IA 136. Now this application. Under Order 1 Rule 10, Clause 2 of the CPC has been filed by the appellant / applicant praying for impleadment of number 1, Miss, you just see from the court title, okay?
Look.
There are 3 of them, 3 names as respondent number.
Before you, Lordship.
Yes.
Lordship, there has been no reason has been cited in the application
Let's see.
for non-employment at the first instance.
Where are you? Which para? Your
Yes,
reasons?
Lordship, nothing has been mentioned. The para 2, you have stated that without the inclusion of these 3 minors, the case cannot proceed. But why they have been left out, that has not been mentioned in the initial stage.
The Lordship, I've given my reasons.
It says out of inadvertence.
Yes, the
In
Lordship.
para 2 is a necessary party, but out of inadvertence. Yes. So Miss such and such, Miss such and such, and Miss and 3 names. Then after that, stop. The applicant / appellant submits the learned counsel for the applicant / appellant submits that the 3 persons, Miss such and such, Mr. such and such, and Miss such and such, is a necessary party in the MSc Appeal number 5 of 2025, but due to inadvertence, the said persons were not impleaded as party respondents in the appeal. Having realized that the appeal cannot be properly adjudicated without impleading the necessary parties, the applicant herein has preferred the instant IA, seeking leave of this court to allow the appellant to implead such and such number 1, 2, and 3 as respondents number 4, 5, and 6 in the MSc Appeal number 5 of 2025. Stop. Para. This court has observed that before the member MSCT Bokchung in MSCT case number 32 of 2022, against which the MSc Appeal 5 of 25 has been filed, the persons sought to be impleaded as respondents number 4, 5, and 6 are also the petitioners number 2, 3, and 4. Stop. Therefore, it is necessary that the parties who were petitioners slash claimants before the learned MSCT Mukokchung should be impleted as parties in the present appeal. Stop. You want me to record your objection?
Lordship, I can say it since your Lordship
Yeah,
has already
because,
come to that. It's all right.
Accordingly, this court is of the view that interest of justice will be served by allowing this application. So, the appellant slash applicant is allowed to implead the said persons, number 1, 2, 3 names, put the names, okay, as respondent number 4, 5, and 6 in the MSC Appeal 5 of 2025. Stop. The appellant applicant shall file the amended cause title within a period of 1 week. That is 136. Then 137. Same order, but just change the thing saying that MSC IA 137 arising out of IA 55 in MSC Appeal 5 of 2025. Okay, and accordingly, change the number in the body of the petition also. Then 130. (138) will be IA 138 in IA number 54 of 2025 arising out of MSC Appeal 5 of 2025. The names will be same. So you amend in all the applications, okay? IAs as well as the main appeal. And then in the main appeal, MSC 5, you say, in view of the
Lordship, one IA has been filed in that also, same, right? In the appeal also,
Yes.
same with the same prayer. That is which one?
no, that is 136.
136,
Yes,
yes.
136. Then list the matter after 1 week.
Lordship, yes, because
Yes, after 1
I've
week,
already filed
we
the,
have to hear on the continuation first.
I've
After
already
1
filed
week
on
for
behalf of all the,
hearing on the IA number. Continuation is which one? IA number 55, 54 and 55
yes.
of 2025. Yes.
Much obliged, Lordship.
Yes. All 3 IAs disposed, okay? Disposed.
For admission, item number 4.
Please, my ladyship. As per the court direction, the spot verification has been conducted. But again, 2 hearing has been concluded, but another 1 more hearing is fixed in the month of August. So I pray that 3 weeks' time may be granted.
Hearing for what?
The Deputy Commissioner was directed to come up with a report. In the course of coming up with that report, the Deputy
Okay,
Commissioner has
after
been
the
calling the
verification.
parties.
Yes.
After the verification. We have also been participating.
Learned Counsel, Ms. V. Shukre, appearing for the sole respondent,
Yes.
has submitted that the verification has been conducted,
Yes.
and accordingly, the next hearing is fixed in the month of
August.
and accordingly, she prays for
4 weeks' time may be
4
granted.
weeks' time
Yes.
to receive further instruction regarding the report. Stop. Learned Counsel for the petitioner, Mr. Ali Ralu is present. List after 3 weeks.
For admission, item numbers 6 and 7.
Your Lordship, in this matter, I have filed my objection to the condonation application this morning. So if this matter may come up after 1 week.
The continuation is which one? IA
IA number
76?
76, yes.
So in 76, you are for the opposite party.
For the opposite parties.
Lieutenant Counsel, Mr. L. Iralu for the opposite party has prayed for one
One
week's
week,
time.
1 week.
1 week's time to file objection.
I filed this morning.
You have filed.
We can take it up on the next.
For 1 week's time, as he has prayed, has filed the objection only this morning. You have received.
Yes, I received.
Learned Additional AG, Ms. Vishupre is present for the state respondents. The list after 1 week.
I'm obliged.
For orders, item number 8.
Yes, who's appearing? State of Nagaland is the petitioner. Yes.
Lordship, we are selling the order that was passed by the learned CGM Kohima law.
Okay, so we are awaiting service report. You have taken steps.
Lordship,
Learned Government Advocate V. Zimomi is present. Stop. Office note dated 25/6/2025 indicates that service report, return service report on the sole respondent is still awaited. Stop. List after 3 weeks, awaiting service report on the sole respondent. How did you take steps? Registered post?
Lordship, through registration.
For hearing, item number 10.
Ready?
Your Lordship, actually the subject matter is very simple. I am challenging the order passed by the PA to DC that is without legal jurisdiction. Sir, citizen.
Wow, who's appearing for the state?
Lord,
Okay. State is 2, respondent 2.
Yes, Your
Who's
Lordship.
appearing for 1, respondent 1?
One is by my senior colleague, Sir Siti Jamil.
Oh, okay.
Your Lordship, the judgment order is at page 39.
39.
Translated type copy is at page 39A, next page. This is an order passed by the PA to DC Kohima. So, my lord, as far as the settled law is concerned, PA to DC has no jurisdiction to pass any judgment as far as the precedence is already set by this honorable court in a catena of decisions. Your Lordship, there was this, the brief facts of the case is, that a contract work was won by the present petitioner. And after executing about half of the work, he ran out of money. And he needed a partner who is the respondent number 1, the father of the respondent number 1. Respondent number 1 passed away. So, Your Lordship, in partnership, they executed the remaining part of the work. Later on, what happened in any contract work, some adjustments here and there are done. So, the actual amount and then the actual amount of the contract work and the actual amount received is also different, much lower. Number 2, Your Lordship, money cannot be divided out of the total amount, because you have to execute the work also. What the respondent wanted was the exact half of the amount of the contract money instead of the sharing of profit. So, Your Lordship, the matter went before in fact, the Dubashi court in the first place should not have the jurisdiction to try the matter because it's a contract matter, but today to shorten the matter, basically whatever it may be the issue, political assistant to the deputy commissioner in the first place has no jurisdiction to adjudicate the matter. And the order is passed by the political assistant to the deputy commissioner Kohima. So, my lord,
Under the rules for administrative justice and police also.
in Nagaland, yes, Your Lordship. So, on the strength of what is in the rules for the administration of justice and police in Nagaland, this Honorable Court in a catena of decisions have ruled that political assistant to the deputy commissioner have no jurisdiction to try the matter. A similar matter I have tried before the coordinate bench of this Honorable Court years back in Tuinsang. The person who was the head Dobashi was handling the matter, and towards the end, before the judgment order was passed, he was promoted to PA to DC, and he passed the order, the matter that he was trying. Still, this Honorable Court held that he was already promoted to PA to DC by the time the matter was the adjudication of the matter was over. So, Your Lordship, I was the respondent in that case, and I took the plea that he was the head Dobashi when the matter was adjudicated. But given the settled principle of law, the matter could not succeed. And this Honorable Court held that PA to DC has no jurisdiction to pass the order. So, my lord, if my lord wants to go into the facts of the case, I will. If not,
No, if you are challenging only the judgment of the PA to DC.
yes, Your Lordship, then page 12, my prayer, Your Lordship, page 12. A. Quash and set aside the judgment order dated 25/5/2019 passed by the political assistant to Deputy Commissioner Kohima without jurisdiction.
It can be remanded back also. To the DC to be tried by appropriate authority.
If it goes before the DC again, Your Lordship, there are some other controversial judgments also which says that subject matter that is not customary cannot be tried by the Dobashi court. So that will also amount to again giving jurisdiction to the.
That is also.
Yes, Your Lordship.
It's between two parties and an agreement between.
Your
But the
Lordship.
problem is this is not arising out of the contract. This is regarding that the shares between the two of you.
Yes, Your Lordship, but where is the share coming from?
It is not a contractual matter.
The share is coming out from the execution of a contract work, Your Lordship. So if my Lord mentions that matter be adjudicated before the appropriate authority, then, Your Lordship, that gives way, not giving jurisdiction to any authority, but at the same time, the jurisdiction in law can be, it will be alive, Your Lordship.
It is only regarding the agreement between the two of you.
That is, an agreement is a contract, Your Lordship, in other words.
It is not pertaining to the work order, that's what I'm trying to say.
Yes, Your Lordship. To that extent, I fully agree, Your Lordship.
Yes.
But what is customary about this is also.
Nothing to do with the work order actually. Of course, PA to DC also is not empowered.
Yes, Your Lordship.
Again, with an agreement to pay the rest of the dues. objection has been filed. Or
Starting from
what it is,
objecting to the
whether you say-
maintainability of the petition. First thing first, Lordship. Kindly come to the
We're
prayer.
only on this, okay, facts, that is different.
Your
But
Lordship.
this is the legal point which we need to decide.
Now, Your Lordship, if we go by the decision of this Honorable Court, the coordinate bench of this Honorable Court, this Honorable Court has specifically held that what is not customary cannot be tried by a customary court. Now, here the question is whether this agreement amounts to a subject matter of customary court. And if the Deputy Commissioner is again given the jurisdiction, if a direction is given to the Deputy Commissioner, then directly or indirectly it amounts to again giving jurisdiction. So if my Lord passes the order, respectfully, my Lord, it is my humble request that the matter be tried before an appropriate forum. Then they may go before the DC, I may go, or before the civil court, Your Lordship, but it does not give jurisdiction
It should
to...
be before the civil court in that case.
Yes, Your Lordship.
First thing first, Lordship.
Yes.
My learned friend is raising the issue of jurisdiction.
Yes.
I also raised the issue of jurisdiction before this Honorable Court. Kindly come to the prayer portion. By approaching this Honorable Court, what the petitioner is seeking for from this Honorable Court. The
Question of the judgment.
No, see, they are seeking a writ of mandamus.
Let's see. To show cause as to why writ of mandamus.
Yes, that is very important. What power this Honorable Court has to exercise?
Your Lordship,
Keeping in view of
and
the
or.
facts. and
It's not just
circumstances of
mandamus,
the
Your
case.
Lordship.
This is a civil revision.
Yes, Your Lordship,
Yes.
but and or certiorari or any other appropriate writ.
And kindly
Lordship.
come to the cause title filed by the petitioner. After Lordship has seen the prayer portion. It is an application under 227 of the Constitution of India, read with Rule 32 of the Rules for Administration of Justice and Police in Nagaland, for issuance of a writ of mandamus and or certiorari.
And or
So-
any other writ. Your Lordship, I have not specifically mentioned the quo warranto and all, Your Lordship, but any other.
In the first place, the petitioner is seeking a writ of mandamus, which is permissible only under Article 226 of the Constitution
Yes,
of
Your
India,
Lordship.
not under Article 227, read with Rule 32 of the rules. This is an application filed by them, not by me. It is your own application that they are seeking a writ of mandamus under Article 227, which is not maintainable. So, the present civil revision is not maintainable in the eye of law, giving in view of his prayer and the cause title and the background under which the application has been filed. That is one. And Lordship may kindly come to one interesting document, which my learned friend has raised. Page 41 of the revision petition. This is an application filed by the petitioner himself before the political assistant to TC Kohima. He is questioning the jurisdiction of the political assistant to TC Kohima, and he is the one who has filed this application. But fortunately, he has refused to accept. And now he is questioning that the PA to TC, political assistant to TC, do not have the jurisdiction to try this case. And Lordship may kindly appreciate one aspect here. The political assistant to DC is the same person who is the head DB.
Was.
To show that, Lordship kindly come to page 34 of the revision petition, Annexure K. This is the show cause notice issued by DB's court, Kohima. and it is signed by head TB's court, Kohima. Now come to page 40 again. See the annexure in page 34, annexure K, head DB's court, Kohima. And page 40, annexure O, political assistant to DC Kohima. Signature is same. So, this is the same person, the head TB. The person who is the head TB is also the political assistant to Deputy Commissioner.
But he couldn't have passed the judgment in his capacity as political assistant.
That-
Maybe in his capacity as
that
head
I
DB.
agree. That I. So it is the government who can give a clear picture whether the head TB is the same person who is the political assistant to DC. And the petitioner is aggrieved by the order passed by the Dobashi's court, not by any other court. Because the complaint was only before the DB's court, not before any other court. And it is the PA to DC, who is the head TB, can issue notice, can also sign in the order. Because DB's court is a court. And in terms of the rules, Rule 23, 24, and 25 of the Rules for Administration of Justice and Police in Nagaland, DBs were entrusted to decide. They have the power to decide under Rule 23, 24, and 25
There is no
of the rules.
dispute about that, about
Yes.
the DBs. But
Now-
we are only on the political assistant.
Yes. Now, another point which my learned friend has submitted is with regard to this is a contractual matter. That is also not correct. Yes, no doubt, initially they agreed to execute a contract. That is already over. Payment has already been made. Now, the dispute is only for the shares of the profit arising out of that. But so far as contract is concerned, it is already concluded. It is a civil dispute between two Angamis. What is the dispute? Dispute is with regard to the shares. That he was supposed to pay me the profit money, which he has not paid. But in the first installment, he has paid 5 lakhs. Thereafter, after the court has passed an order, he did not pay the amount. Therefore, a show cause notice was issued. In fact, warrant was also issued. That time, he has paid another 2,70,000 pursuant to the order passed by the DB's court. And there is no different order, one order passed by the DB's court and another order passed by the PA to DC. The order which has been signed by PA to DC is the order which has been passed by the Dobashi's court. Because the head DB is the PA to DC. Only the designation is different. Therefore, now that he is questioning the jurisdiction, pursuant to the judgment passed by the DB's court, he has deposited a sum of rupees 2,70,000 and assured the court that I will pay the remaining amount at the earliest. Date has also been shown. Now, kindly come to page 19, page 9 of the civil revision filed by the petitioner, paragraph 19.
Yes.
May I read, Lordship? That the petitioner by letter dated 3/10/2019 requested for withdrawal of the warrant of arrest and paid rupees 2,70,000 to the District Customary Court Kohima on 5/10/2019. By the payment made on 5/10/2019, the total amount paid to the respondent number 1 stands at 10,70,000 rupees. So this is his statement, and this payment has been made pursuant to the order passed by the Overseas Court. He has admitted to the jurisdiction, submitted to the jurisdiction, and now he is turning around and approaching this honorable court, contending that the DB's court do not have the power to decide this. So it is nothing but an afterthought so as to delay in making the payment, nothing else.
Why can't you settle these things outside of court?
I would be more happy. Lordship, can you see?
We should have sent this for the mediation.
Actually, agreement is, understanding was with my father.
It is only regarding the amount, isn't it?
Expired.
In fact, Your Lordship.
And then the present petitioner has substituted his father. And then there is an order of the court. And it is an admitted fact in all the documents, whatever has been translated in terms of the court order. He has admitted that, yes, I'm liable to pay, I'm liable to pay. So whatever direction Lordship gives for amicable settlement also, in fact...
No, since the mediation drive, nationwide mediation drive
Lordship.
is going on, should we refer it?
In any case, Your Lordship, the problem with my client is that he was willing to pay from day one, but the respondent number 1, the father of the respondent number 1, more particularly, he wants the exact half of the amount of the contract amount for which they executed the work. So how is that possible? So that is the reason why he approached my chamber, and then we, of course, I have seen, and then...
No, that's why it is only regarding the amount.
Correct.
Yes, Your Lordship.
Correct.
So that can...
8,63,000.
That can
That
always
is their
be,
demand, Your
that
Lordship.
can always be
Yes.
settled across the table, isn't it? In a mediation proceeding, it's possible.
That is possible, Your Lordship.
It's a petty matter actually.
That's why I'm saying.
Petty for us, Your Lordship, but for a small man, it is a huge amount. So, but yes, Your Lordship, can they refer to mediation also?
If the parties are willing, because right now we are identifying cases to refer to mediation, and the High Court is also,
Your Lordship.
Kohima bench has not been able to give many cases, so they are insisting that we should refer more.
But my learned senior colleague will never get the amount he is demanding, Your Lordship.
Let them decide.
No, let them decide. Let them decide. Just call this statement. Yes.
Here, the petitioner, he has impleaded the deputy commissioner as a respondent number 2. However, he is challenging the judgment passed by the Dobashi's court.
Yes.
So any court cannot be impleaded as a party. So my prayer is that the respondent number 2 should be deleted. Lordship,
On that point,
Yes.
suppose, my learned, if the matter keeps pending and then one day or the other it has to be decided, in that case, the dispute and issue with regard to the head TV and the PA to DC. He is the same person or not, it is the deputy commissioner who can say.
It doesn't matter, Your Lordship.
No, but he is challenging.
I'm saying that.
So that means you have not filed a counter affidavit?
No.
See.
Because
Yes.
the petitioner cannot implead the court as a party respondent. Simple as that.
This is not the court for that matter in this issue.
Upon hearing the learned counsels for the parties and on going through the pleadings, this court is of the view that there are ingredients for settlement in the present case. So, accordingly, the matter is referred for mediation under the nationwide mediation drive. The parties shall appear before the registrar of the Gauhati High Court, Kohima bench, give a date
Lordship, sufficient time may be given so that we have to again talk to them and then see.
No.
It is a 2019 matter.
During
and
the
this
mediation, they will be
arising out
given
of
opportunity to
2015.
appear 2-3 times, 3
Yes.
sittings, 4 sittings will be
Yes.
there.
Yes.
So just to fix the date,
My lord,
to
your
appear
lordship.
before the registrar and fix the
An
date.
early date may be fixed.
Yes, that's why. Appear before the registrar, Gauhati High Court, Kohima bench on 11th, on 11th August.
11th of August.
Or next
is
week
a
also,
Monday.
on 4th. 4th is too early,
What occurs will be too early.
then 11th. Because this mediation reports we have to submit by
Lordship,
September.
11th I will not be available, but I think it should be okay to inform them to appear before the registrar.
No, on the first day, at least the council should be there also, no?
Yes, Lordship. So 11th I will not be available.
Then in that case, the week before that, 6th, 7th, 8th,
It will be on 7th.
7th,
7th.
on 7th August 2025, and thereafter the registrar Gauhati High Court shall appoint the mediator for the parties. So place the matter before the court after the mediation proceedings, along with the report. So,
The respondent number 2 may be deleted. Respondent number 2, who is the deputy commissioner?
we'll see if the mediation fails, then because if
Lodge,
the
Lodge.
mediation is successful, then the case will be over.
Lordship.
For hearing, item numbers 11 and 12.
Yeah, please, Your Lordship.
Yes, what matter is this?
Your Lordship, here both the petitioners are praying for minimum scale of pay. Your Lordship, however, there's an office memorandum, Your
Isn't
Lordship.
that covered by that
Your Lordship,
2025?
here in item number 11, that is read petition number 226 of 2022. It's a bit different. Why? Because verification was not conducted here. As per the office memorandum, the district level verification committee has to, verification was to be conducted.
Have you handed over a copy of that?
Your Lordship, can I allow me to place before Your Lordship?
Whose names have been duly verified?
Yes.
Otherwise, this 273, it is verified.
Yes, my
It
lord.
can be covered.
Yes, yes, my lord. Your Lordship, kindly allow me to place before Your Lordship the list of the employees who's, who had not undergone the district level verification committee. Your Lordship, this is the list of establishment
But who
employees.
did not undergo the district level verification?
And Your Lordship, the petitioner's name is at serial number 59, H2. Serial number 59. Terohing driver.
59.
Yes, my lord. The last one.
Why he did not appear before the verification committee?
Your Lordship, I have learned that he was not aware. Your Lordship, here I have received a notification also, so kindly allow me to place. Your Lordship,
Who have missed out the verification? Acha. So, in view of this, another verification is to be conducted.
yes, Your
That
Lordship,
means-
it was supposed to be conducted within 45 days. Your Lordship, however, till date, the time have already lapsed. However, till date, no verification was conducted.
Acha, Mr. Muan, what's the position now? Because the first verification, the petitioner missed out. So again, the government constituted another committee
Yes.
by 26 May 25 notification to consider those who have missed out
Yes.
on the verification and to verify again. Then they were supposed to conduct their verification exercise within 45 days. So what happened after this?
Direction be issued so that the petitioner can be included.
So that means they are yet to conduct the verification
I think.
in view of this 26 May. No, you have to be sure. Because if verification is already conducted and the petitioner is not aware, are you sure that it is not conducted?
Yes, my lord. Your lord, in that case, let the state respondent receive instruction.
I think that is better. You get specific instruction as to whether in view of this notification of 26, you have a copy, no? 26 May 2025, whether the verification has been conducted for those who have missed out. And if not done, when it will be conducted, so that a direction can be given. So when can we fix it? After a week? Or it can be tomorrow, day after also?
No, this chairperson has been transferred out. I have to find out, your ladyship. Because the first person, the chairperson has been transferred out now. So I'm not sure. Who are the members now?
Acha, what you do is, I'll give you 2 weeks time. You file an affidavit stating as to whether the petitioner can be considered under this 5th March 2025 memorandum, and also whether this notification dated 26, whether in view of this notification of 26 May 2025, the second verification for those who have missed out, whether that has been conducted, and if not, when it will be conducted, no? And accordingly orders can be passed.
Yes.
Okay.
My lord, yes. In item number 12, that is petition number 273 of 2022. My lordship, the petitioner, as per the office memorandum, which I've placed earlier, that is on the office memorandum, 5th March. Your lordship, here, the petitioner's scale of pay was supposed to be granted with effect from 1st May. However, till date, your lordship, she has not received the scale of pay.
We'll come
The
to
scale
that
of pay was
later.
not granted.
First, we'll deal with this the first rate petition. Heard learned counsel for the petitioner,
Mr. Criseno.
Criseno, and for the petitioner, and Mr. Mo Imchen for the state respondents. Mo Imchen, senior government advocate for the state respondents. You're also there?
Yes, in fact, I have no role to play.
And Mr. N. Muzui for the respondent number. Respondent number 10. Respondent number 10.
8.
No, respondent number 10. Accountant General is respondent number 10. WPC 226.
Yes, 227.
At the outset, the petitioner has produced a copy of the office memorandum number AR-3/GAN/67/2001 dated 5th March 2025, by which the state government had taken a policy decision for conversion of wages of work charge and casual employees to scale pay as per revision of pay 2015. Stop. It is submitted that in the said OM dated 5th March 2025, the condition is that the work charge and casual employees in all the departments ought to have been duly verified by the district level verification committee and registered in BIMS before the benefit under this OM could be granted. Stop. It is stated that the petitioner was not included in the district, that the petitioner did not appear. Why he did not appear?
Your Lordship, he was not aware, the petitioner was not aware. Yes.
That the petitioner was not aware about the verification and therefore did not appear before the district level verification committee. Stop. Thereafter, the government of Nagaland, by another notification number AR-3/GAN-67/2001, open bracket, volume dash Roman 1, close bracket, dated 26th May 2025, constituted another committee to conduct an exercise to verify contingency, fixed and wage paid employees and all those work charge and casual employees who have missed out on the verification conducted by the district level verification committee during 2014 to 2016. Stop. The said committee was to conduct this verification exercise within 45 days. Stop. The counsel for the petitioner submits that such verification has not been conducted till date. Stop. The learned senior government advocate, Mr. Moa Imchen, is directed to file an affidavit stating as to whether the petitioner can be considered for grant of scale pay in terms of the office memorandum dated 5th March 2025, and also state whether the committee constituted by notification dated 26th May 2025 has conducted the verification exercise. Stop. And if the verification exercise has not been conducted, to give a specific, to get specific instructions as to when the verification will be conducted. Stop. The affidavit shall be filed. Did I say that? Give the timing. Did I say 2 weeks? Release the matter after, say 3 weeks. Release the matter after 3 weeks. Before which date the learned senior government advocate shall file the affidavit.
What's your question?
No, my lord.
No. This one, he
Verification
has
is
already undergone the verification. So I think it can be disposed of, na?
Yes, ma'am.
Okay, now this is WP 273.
Your Lordship, here the petitioner scale of pay was to be granted on with effect from 1st April 2025. Your Lordship, however, till date her scale of pay was not granted.
Was to be given with effect from
1st
April.
Yes, my lord. April 2025, as per the office memorandum.
Oh, अच्छा.
Yes, my lord.
Yes, as per this OM, it says 1/4/25. Yes. So now, are you getting your scale pay?
No, my lord.
Not
Till
yet.
date. Your Lordship, specific direction may be given.
The present writ petition has been filed by the petitioner, Srimati Pauni, Pauni, who was appointed as the contingency. Where is your appointment order? As a contingency paid animal attendant on fixed pay of rupees 3,000 by an order dated 4th April 2012. Stop. The petitioner submitted representations seeking for granting of scale of pay. Stop. However, the petitioner's representations were not considered. Stop. During the pendency of were not considered. Stop. Hence, being aggrieved, the present writ petition has been filed, praying for grant of minimum scale of pay to the petitioner. Stop. During the pendency of this writ petition, the state government has issued an office memorandum number AR-3/GEN-67/2001 dated 5th March 2025, by which the state government had conveyed an approval for conversion of wages of work charge and casual employees to scale pay as per revision of pay 2015. So, the said OM states that all work charge and casual employees in all the departments whose names have been duly verified by the district level verification committee and registered in PIMS receiving fixed pay shall be granted scale of pay as per the revision of pay 2015 with effect from 1/4/2025. Stop. The OM dated 5th March 2025 also directs all the departments having work charge and casual employees to expedite the conversion accordingly. Stop. After this, was your name sent?
No, my lord, verification was conducted earlier.
Earlier.
Yes, my lord.
The counsel for the petitioner, however, submits that she is yet to receive the scale of pay till date. Stop. Learned Government Advocate, Mr. Moy Chen. What did you say in your counter affidavit? Oh, but after you filed your affidavit, only this scheme came. Okay. Mr. Moy Chen, Learned Senior Government Advocate, has not disputed that the office memorandum dated 5th March 2025 provides for conversion of fix and conversion of work charge and casual employees on fixed pay to scale of pay as per ROP 2015. Stop. This petition is therefore disposed of with the direction to the respondents number 1 5, 6 and 7. 5, 6 and 7 to consider the petitioner's case under the OM dated 5th March 2025 and to grant the scale of pay with effect from 1/4/2025 as provided in the OM dated 5th March 2025 within a period of 3 months, from the date of receipt of this order. Just this. Yes, yes. Earlier, no, you just say heard such and such, and there you say N Mosui for respondent number. Here, I think it's 8. You have already issued the OM. Why are you taking so long? It should be implemented, no, at earliest.